begin with Nancy from the IRB. Thank you, Nancy.
I should, first of all, thank you. First of all, thank you very much to James for inviting me to speak today at this conference. This is an issue that I've been interested in for many, many years, probably since the early 90s when we first started getting these cases at the board. I should say I'm a legal advisor with the Immigration and Refugee Board. I'm based here in Toronto, and I've been with the board basically since its inception. Almost from the very beginning. The board started in January of 1989, and I started with the board in September. So I've basically seen the development of all this case law from the Federal Court of Appeal, and in some instances the Supreme Court of Canada. Although I am an employee of the Immigration and Refugee Board, my remarks in speaking to you are not officially on behalf of the board. But as I said, this is an area that I have spent a considerable amount of time researching and looking at over the years. First of all, we are familiar, of course, with the 1951 Convention and Article 1FA, and my focus, even though Article 1FA refers to crimes against peace, war crimes and crimes against humanity, the focus for my talk at least, because I'm going to be speaking about the Canadian jurisprudence, Canadian case law, and the experiences of the board and in the Federal Court of Canada, the focus will be primarily on crimes against humanity. And the reason for that is that basically the case law has developed over the last 20 years in such a way that human rights violations, the individuals who we see who have come to Canada seeking asylum, seeking convention refugee status, when we look at issues of exclusion, the case law has basically developed that violations of human rights have basically centered on the concepts of crimes against humanity. And I won't go into reasons why that's happened. Sometimes there's a lot of overlap, as you know, between a war crime and a crime against humanity, and crime against humanity being specifically crimes, human rights violations committed against civilians, whereas war crimes are more expansive than that. But the focus of the board, and therefore the case law in Canada, has focused mostly on crimes against humanity. The IRPA, Immigration and Refugee Protection Act, which is our domestic legislation here in Canada, which is soon to take on a new name, which right now we refer to as IRPA, and we have a new act. There are some major changes coming to the board. For those of you who are familiar with it, we're adding an appeal division, the RAD, and IRPA will be known as BRRA, and yes, already at the board we are referring to it, which I hate, but I suppose I have to get used to, as the BRA. I wish they had come up or thought about that when they actually enacted the new legislation, but unfortunately it looks like we're stuck with it for a while. In any event, Section 98 of IRPA incorporates the definition, 1951 definition, including as a schedule to our Act, Article 1FA. And so that's what the focus is. Now, in interpreting what is a crime against humanity, generally, from the very beginning, the board has looked at, because we're required under the 1951 Convention to look at other international instruments, and of course, back in the early 90s, at the beginning of the board, all we really had to look at, there were other international conventions and instruments, but the main instrument that we considered and that the federal court directed the board to look at, of course, was the Charter of the International Military Tribunal, also known as the Nuremberg Tribunal, and Section 6 of the Nuremberg Charter, which provided a definition of crimes against humanity. And so that was sort of basically our starting point for what constitutes crimes against humanity. And whenever there's an actual asylum claim, a convention refugee claim, the members, in addition to members of the board, in addition to considering and looking at who is included and who's entitled to asylum, who's entitled to convention refugee status or protected person status, as we refer to now, will also look at whether an individual may be excluded. I'm hesitant now after James' talk to talk about those individuals who are undeserving of Canada's protection, but let's say persons who might be not the recipients of the human rights violation, but who may have actually been the perpetrators of the human rights violation. And those persons who may have committed a crime against humanity or been complicit in a crime against humanity. And what I'm going to talk about very briefly in terms of what is a crime against humanity and the experiences of the board, but mostly I'm going to focus my time on how the concept of complicity in Canada, complicity in crimes against humanity has developed since the early 90s here in Canada. This is just a notion of these concepts of complicity, and I won't say much more other than it has as its basis in the Nuremberg Charter. We're also looking, since 2002, the board members will also look at and are required to look at the Rome Statute and the definition of crimes against humanity there. As you know, and those of you who are familiar with the Rome Statute, the definitions of crimes against humanity are much more expansive in Section 7 than appeared at the Nuremberg Tribunal, and of course the board members will have a look at in detail. And all of these in Section 7 of the Rome Statute of the ICC, all of these terms are defined in further detail. So members will look at that as well. We also had a major decision of the Supreme Court of Canada called Mugasera in 2005. And the Supreme Court of Canada, Mr. Mugasera, the Supreme Court of Canada looked further at what would define a crime against humanity in the context of, in Canadian jurisprudence. And the Supreme Court of Canada had a look at a lot of the existing jurisprudence. Mr. Mugasera had given a speech in Rwanda prior to the massacre. He gave a speech to individuals, and basically it was a form of inciting individuals to rise up against the Hutus, the Tutsis rather, and what the Supreme Court of Canada had to look at was whether this incitement, this speech that Mr. Mugasera gave, whether this was inciting crimes against humanity, and whether this in itself was an act that could be considered a crime against humanity. And so basically, this is what the Supreme Court of Canada said, that a crime against humanity, one looks at the actual act. In this case, it was the actual speech that was given, but it doesn't matter. It's whatever that act might be that might constitute a crime against humanity. But what would take an ordinary crime that would normally be prosecuted under domestic legislation and what elevates it to an international crime? Something that we would call a crime against humanity. And so the Supreme Court of Canada, looking back over all the jurisprudence and international jurisprudence as they did in this decision, and said it had to be part of a widespread or systematic attack directed against a civilian population, and that there had to be knowledge that the person knew of the attack or took a risk that his or her actions would form part of that attack. And that's basically what the board looks at, what RPD, Refugee Protection Division members, look at in determining whether an act is a crime against humanity. Now, as you know, obviously, a lot of our claimants, most of our claimants come from refugee-producing countries where they are alleging that they are victims of human rights violations. Now, if they were a member of a national army, if they were a member of a secret police force, if they admit to being a member of a death squad, if they admit to being a member of an organization that's been identified as a terrorist organization or an organization that commits human rights abuses. Then we are looking at what they've actually done, or what they've contributed, and what the organization has actually done in terms of whether it fits within this definition. Now, a number of, I would say most of our claimants where there has been an issue of exclusion under Article 1FA, and where there's been a finding that the person has been complicit, we don't have necessarily evidence that the person has actually committed a human rights violation. The issue of exclusion generally arises, and under Article 1FA generally arises, because the individual, as a member of a national army, or in a death squad, or in a group where we have documentary evidence that has committed human rights violations, that others in the group to which the claimant was a member has committed human rights violations and perhaps crimes against humanity. So the experience and the majority of our exclusion cases, and I guess the majority of those cases in the statistics, involve individuals who haven't, in a physical sense, there isn't, or at least we don't have evidence that they have, in a physical sense, committed an actual human rights violation. But it's because of their membership in a group, or they have contributed in some way to an organization, and there is documentary evidence that others in that organization have committed human rights violations that are tantamount to crimes against humanity. And that is basically how, in a nutshell, that is how the jurisprudence in Canada at least has developed with respect to Article 1FA. And I would say well over 90% of the cases dealing with Article 1FA, crimes against humanity and exclusion here in Canada, are individuals who have not, in a physical sense, that there is not evidence before the board that they have, in a physical sense, actually committed the act of torture against another individual, has shot a prisoner. There's no evidence that that individual, because it's not part of their story, they come and they make a claim and they tell us why they should be included in the Convention Refugee definition or in protected person status, why they're entitled to protection here in Canada. And then when we look at the whole picture and we look at their whole story, we look to see, well, they were a member of a certain army, they were a member of a death squad, they were a member of an organization that's been identified as a terrorist organization. And we don't necessarily have evidence, they don't necessarily are admitting to committing an act of torture. But we look and ask ourselves, are they complicit? And how we determine that is we look at the jurisprudence from the federal court, because the federal court is binding, of course, on IRB members, on Refugee Protection Division Order members, and this is where we get our guidance. And over the years, and certainly since one of the main cases, which is a case that most of you, I'm sure, are familiar with, the Ramirez decision, where the concepts of complicity in crimes against humanity probably first arose, and that is sort of our starting point. But of course, there are hundreds of cases that have developed over the years, taking into account different fact situations. And I'm going to go over some of those. Now, what's very interesting, of course, is that, I don't know if you're familiar with this case, this is a very recent case of the Federal Court of Appeal. So I think James mentioned that generally there's a decision from the Refugee Protection Division. Let's say the Refugee Protection Division member, it's a single member, makes a decision and decides that the person is complicit in crimes against humanity and the person is subject to exclusion under Article 1FA. The decision then, there's a possibility that the claimant, the person that was rejected based on exclusion, will seek judicial review in federal court. Not an appeal. It used to go to the Federal Court of Appeal, but it isn't any longer. It goes to the federal court. federal court will make a decision, and that's what happened in this particular case with Mr. Ezekola. And the federal court made a decision, single judge made a decision, and certified a question to the Federal Court of Appeal. And basically what the Federal Court of Appeal, over the years, the Federal Court of Appeal has ruled on matters with respect to exclusion, and the Federal Court of Appeal did so in this particular case. So the lower court didn't agree with the exclusion of Mr. Ezekola, and then it went to the Federal Court of Appeal. At the Federal Court of Appeal, the Federal Court of Appeal disagreed with what the lower court did, and I'm going to show you what the lower court decided and why. And it's very interesting because in addition to taking into account the existing jurisprudence, the federal court, the lower court, looked at the Rome Statute, looked at section or Article 25 of the Rome Statute, and also looked at some international jurisprudence, which doesn't happen very often, I'll admit, in the Federal Court or Federal Court of Appeal jurisprudence in Canada. Well, the Federal Court of Appeal looked at it, and actually it's quite interesting, just as a side note, in that the judge of the lower court made the decision, and very shortly after that was promoted to or joined the Federal Court of Appeal, but of course was not on the three-member panel that decided this case. I won't say that the Federal Court of Appeal was necessarily very critical of the lower court decision, but certainly they made it very well known in a number of passages, if you read the decision, that they strongly disagreed with the findings of the lower court. So who is Mr. Ezekola? Mr. Ezekola came to Canada and he claimed refugee protection before the board, and he was excluded. Why? Well, his story is that, and this is the story, most of the evidence, remember, that we have at the board is the evidence as told by the claimant himself or herself. We almost never have independent or other evidence that's placed before us. It might happen that we have country condition, or we do have country, always we have country condition documents, we have Human Rights Watch, we have Amnesty International, we have various reporting services that tell us about the conditions in a country, but it is very, very rare that we will have actual testimony from anyone other than the claimant himself or herself. So Mr. Ezekola told us that he had been employed for 9 years in the government of the DRC, Congolese government from 1999 to 2008. He was assigned to the permanent mission of the DRC, and he led the permanent mission of the DRC and spoke before the Security Council. Based on this information, the Refugee Protection Division, so this is the division at the IRB, found that the DRC, during that time period, there was documentary evidence, an abundance of documentary evidence, that the DRC government had committed crimes against humanity, or the acts committed by others, not Mr. Ezekola, there wasn't evidence of that, but by others in the DRC had committed crimes against humanity. And they concluded, the RPD concluded, that because of his high-level position and that he had represented his country abroad, he was aware, actually, he didn't admit to having knowledge of the human rights violations, but the RPD member, the Refugee Protection Division member, found that based on the number of years that he was in the government, services of the government in the DRC, and just the notoriety of the human rights abuses, that they imputed knowledge, and they said he had to have known. So therefore he did have knowledge. And basically that he enabled, by the work that he did, he enabled his government to perpetuate itself. He didn't dissociate when he would have become aware of the human rights abuses, and therefore he was complicit. And following along the lines of Ramirez and the other case law in the federal court, that he shared in the common purpose, and therefore he was complicit in the crimes against humanity, and therefore he was excluded. The lower court, the lawyer for Mr. Ezekola, so now he's excluded and he's denied refugee protection, and he seeks judicial review in the federal court. And the lower court disagreed with the board. The lower court said, no, this is not how someone should be found complicit in crimes against humanity. The lower court said that Mr. Justice Mainville said that there has to be a personal nexus between the claimant and the crime. So remember what exactly Mr. Ezekola had done, or what he said his role was in the DRC. He actually said that he was in the permanent mission to the UN, and he regularly represented the DRC at the UN committees and agencies. And he did this for a period of about 8 or 9 years. Lower court said you have to personally participate in the crimes, or personally conspire to commit them, or personally facilitate their commission. Now, the lower court came to this finding based on a review of international jurisprudence. And I won't go into that now, as Joseph is going to talk about in more detail that jurisprudence, but that's the finding of the lower court. So then it goes on to, then the Federal Court of Appeal said that this was too narrow a test for complicity in requiring personal participation, and said this is not what the test is for complicity, and set out to review the existing case law. And basically, based on their review, and I'll show you quickly what that review is, the Federal Court of Appeal said that a senior official may be complicit in crimes in his or her government if he remained or she remained in that position without protest, continued to defend the interests of the government, and was aware of the crimes committed. So that was basically the finding, and here's why. So what the Federal Court of Appeal did was actually make my job very easy today in reviewing all of their own jurisprudence. So the Federal Court of Appeal started with that first case, which is Ramirez. And the Ramirez is this personal knowing participation test that James mentioned. And basically, the Federal Court of Appeal, and this is back in 1992, so we're nearing its 20-year anniversary, the Federal Court of Appeal said no one can commit crimes against humanity, international crimes, without personal and knowing participation. And basically said complicity rests on the existence of a shared common purpose and knowledge. Now, the next bit is something that I think has been the most misunderstood and probably has caused us at the board a lot of grief, and I think the federal court as well, because it hasn't been entirely clear what the federal court meant. And this was a way of, in this decision, the Federal Court of Appeal clarifying the concepts of complicity. But the court looked at this and said there are basically a couple of kinds, two kinds of organizations. There are organizations when you're looking at the claimant saying, I was a member of this National Army. So the National Army is the focus. So now we're going to say, what kind of organization is this National Army? Is it an organization which from time to time commits international offenses? The court says in Ramirez that's normally not sufficient for somebody to be a member of that type of organization for them to be found complicit in crimes against humanity. Remember, an individual who hasn't physically committed an act of torture or pulled a trigger. But where an organization is principally directed to a limited brutal purpose, mere membership, and here's the important line, I think, may by necessity involve personal and knowing participation. And I think it's important to stress that it says mere membership may by necessity. It doesn't say mere membership involves personal and knowing participation, because there's still more analysis that needs to be done, even in a sense of a limited brutal purpose organization. For example, knowledge. Did the person have knowledge of the crimes committed? How long was the person in that organization? Because you can't even determine whether the person may have had knowledge or impute knowledge unless you look at a series of factors to determine whether it's possible to impute knowledge on the part of the individual if the individual denies knowledge. Now, Mr. Ramirez had been a soldier in the El Salvadoran military during the time of the Civil War, and he admitted to knowing that there were human rights abuses being committed out in the field, and that persons were tortured in the field when they were detained during the time of the Civil War, and that then when they were sent to torture centers in San Salvador, and he knew about that. So that wasn't an issue in the actual Ramirez decision. Now, what is a limited brutal purpose organization? Well, there have been a series of cases, and I won't go into much detail about it, but basically there have been a number of decisions. It's not just a terrorist organization that is principally directed to only committing acts of terrorism. National armies have also been identified, or death squads have been identified. Well, death squads, I think that's fairly obvious, but even national armies or police forces where there has been an abundance of human rights abuses being committed have been identified by the federal court as being limited brutal purpose organizations. So it's not strictly of what we think of in terms of a limited brutal purpose organization being a terrorist organization blowing up people. This is a limited brutal purpose organization. It's actually been interpreted as being much broader. And one case defined it as an organization as a limited brutal purpose if its violent activities can't be separated from other objectives. So the court also went on to look at other cases as well. And for example, in Sivakumar, Mr. Sivakumar had been a high-ranking member of the LTTE. Basically, in this case, the Federal Court of Appeals said it's a broad concept, and the person is not limited to, and the analysis of complicity isn't limited to just persons who are a physical participation. In the next case, Mr. Bazargan, he had been a senior liaison officer between the police and SAVAK, which is the Shah's secret police in pre-revolution Iran. And there, of course, is much documentary evidence about human rights abuses, horrible human rights abuses committed at the hands of SAVAK, and we've accepted numerous individuals who've had issues as a result of that, individuals here in Canada. And this was a case that stood for the proposition where the Federal Court of Appeals said it's not just persons who are formal members. In this instance, we're talking about SAVAK, but Mr. Bazargan was in the National Police in Iran. He wasn't in SAVAK. But because he was the senior liaison officer and he gave information to SAVAK, he wasn't formally a member, so the Federal Court of Appeal in this case said you don't have to be a formal member of the organization to actually be complicit. In this next case in Harb, the court basically said exclusion applies even if the specific acts committed by the person are not crimes against humanity. So you look at the crimes of others. The court also looked at, because the lower court raised it as well, and looked at Article 25 of the Rome Statute and said this is when criminal responsibility attaches, and focused on the notion of any other way contributes to the commission of the acts in question. And basically the court said that criminal responsibility for international crimes falling under the Rome Statute is not limited to personal participation, and therefore the lower court is wrong, and the personal knowing participation test in Ramirez is in harmony with the Rome Statute. Now, Joseph is going to talk about the JS case, so I'm not going to. However, the court also looked at the JS case, and again, it is unusual for the court to be looking at international jurisprudence, but the court did address it, and basically, without going into detail, said that if you look at what the court actually said, the Supreme Court of the UK in the JS case, that only personal knowledge of the crime and intention to contribute to their commission is required, and that this is also consistent with Ramirez. Now, there is another case that was decided actually before Ezekola. It's just a decision of the federal court. And it talked about something called this presumption of complicity. And there have been some cases, including a Federal Court of Appeal decision, there have been some cases that talk about this notion of a presumption of complicity. And I think that, if I emphasize anything else, has been probably very misunderstood and underutilized and underused. It was referenced in another decision of the Federal Court of Appeal from a few years ago, which basically said that if a person is a member of a limited brutal purpose organization, that there is a presumption of complicity and that the claimant can rebut that presumption. But it doesn't say that there is an absolute exclusion of somebody just because they were a member of a limited brutal purpose organization. That you still have to look at, for example, in that particular case, there was an issue of duress that was not looked at. And so because the issue of duress was not considered, this case was sent back for reconsideration because, of course, the defense of duress can absolve criminal responsibility, and in the context of exclusion and refugee determination, it can absolve complicity. And so in this particular case, this judge said, really, you're considering the presumption, but you should also look at the factors that have been developed. And the number of factors that have been developed in terms of complicity, this is what should be considered and looked at in determining complicity. As a result, and there is a handout, and I have a handout of all of my slides, and basically for the balance of the slides talks about the types of individuals over the years that have been excluded for complicity. This is the chief judge of the military court in Somalia. He was excluded from refugee protection. This is similar to the justice trial at Nuremberg. The facts speak very similarly to this fact situation. Another example was an individual who was a director of a prison in Afghanistan where political prisoners were tortured. Another example, well, we already looked at Bazargan. Another example is a person who was in the BNI, the Internal Security Agency in Ghana. Again, no evidence that the person had actually committed crimes against humanity, but because of his membership and knowledge that may or may not have been imputed, he was excluded. Again, somebody who was head of a village in China and oversaw the implementation of the one-child policy, where forcible abortion and forcible sterilization, an ambassador, a person who was an intern at a hospital in Rwanda, and a director of the civil service in Burundi, a special guard in a prison in Georgia. So basically we see a wide array of individuals at the board who have been excluded on the basis of complicity in crimes against humanity. And this recent Federal Court of Appeal decision, which sort of tying all of the federal court jurisprudence over the last almost 20 years. And that's generally an example of the type of cases that we see at the Immigration and Refugee Board. Thank you.
Thank you very much. That was very thorough.